Good morning, everyone. My name is Robert Crea, and I'm an investment management attorney at K&L Gates. And I want to speak with you for a few minutes today about what I perceive will be happening in the ICO and cryptocurrency space in 2018. And as you might recall, last July, the SEC delivered this report on the DAO. And in this report, the SEC found that DAO tokens were securities. And when a token is a security, it has cascading implications under a variety of US securities laws, specifically related to investment advisors and broker-dealers, which is of particular interest to me in my field. But these laws also have implications for other intermediaries, such as consultants and exchanges, and also lawyers and accountants. And so these are things that is very important to keep in mind when you're moving into this space. In this space, my firm is involved in a variety of areas, including private cryptocurrency funds. We're also advising on a number of regulated token offerings. We're doing some interesting policy work now on the possibility of retail registered funds, which, by the way, won't be happening in 2018. We're also doing a variety of litigation matters, and we're also experts in the money transmission laws applicable to this space. On utility tokens, given the very clear statements that came out of the Munchie cease and desist order, and also from SEC Chairman Clayton, we take the position that every token that is sold has a rebuttable presumption that it is a security, which leaves open a question: what do you do with all the token sales that have already happened? So, and the answer to that question is not good. The SEC could actually seek disgorgement. There's also probably rescission. And you have a number of people saying, well, SEC, what do we do? Well, the SEC doesn't have the final say, because each time that there's a violation of securities laws, often it is coupled with a variety of private claims that can also be alleged. So in the regulated token space, there are basically three pathways, and these pathways, none of which are very good. There's regulation crowdfunding, A+, and 506C. Regulation crowdfunding limits you to a fundraise of $1 million a year and doesn't preempt any of the state blue sky laws. A+ gives you $50 million a year, but you have to get pre-approval from the SEC. You have to get audited financial statements, which often doesn't make sense for a startup. And also, it's very expensive from a legal standpoint, and there is no guarantee that the SEC is going to approve any of the A+ offerings that are presently before it. So that's 506C, unlimited in terms of the amount of capital you can raise, but it sticks you with restricted tokens in terms of transferability. People are talking about, well, it comes to rest for a year, and then you can rely on Rule 144. But Rule 144 has a lot of catches, and don't anticipate that your 506C token is going to be able to trade freely like what you're seeing on the existing cryptocurrency exchanges. Additionally, there is not a single alternative trading system, despite marketing statements to the contrary, that has been approved by the SEC. So even if you spend all this money to create a regulated token offering, there's no guarantee that there's going to be an exchange on which you can actually trade, which is a big problem in this space. In addition, look at the existing cryptocurrency exchanges that are presently out there. There is a heightened amount of scrutiny of these exchanges right now, and it's going to get worse in 2018. The scrutiny is focusing on whether or not any of these cryptocurrency exchanges are hosting unlawful trading in securities. And the scrutiny is also going to be focusing on whether or not they're compliant with applicable law. And let me tell you, from the work that I'm doing with financial institutions, there is a lot of interest from professional sell-side institutions in the possibility of retail products in this space. But they are not going to move into this space until they know that the cryptocurrency exchanges that we have are up to snuff with respect to their regulatory infrastructure. And there are also problems with the pseudonymity of the trading on these cryptocurrency exchanges. We're also probably going to get some guidance in 2018 as to who oversees the exchanges. The CFTC chairman recently said that the CFTC doesn't have spot authority, and SEC Chairman Clayton says it all depends upon whether or not the underlying instruments are actually securities. So, what does that mean? 2017 was a year where we were looking at whether ICO tokens were securities under Howey. 2018 is going to be the year where we're going to be looking at whether or not any of the existing primary cryptocurrencies are securities. And that's going to focus on historical analysis on the manner of sale of offering and also the existing scope of curation of these cryptocurrencies. And the SEC doesn't have the final say on any of these questions. There is class action litigation that's cropping up across the country, and any district court can actually have a finding that could have cascading implications for this entire industry. And we could also get conflicting viewpoints from district courts that only will get conformed through an appellate process that will take some time. In terms of enforcement actions, We're anticipating that there are going to be continued actions against token sponsors, but we also expect that there are going to be actions against the intermediaries, specifically lawyers, law firms, accountants, and consultants. And these actions are going to be made in the spirit of reminding these professionals of their responsibilities as gatekeepers of investor protection. Thank you.